Okay, drug crimes. I love defending drug crimes. That's been my focus throughout the course of my career. And quite honestly, when it comes to the elements of a crime like this, you're dealing with probably one of the simplest types of criminal offenses when it comes to the elements and what the prosecutor must prove. Drug crimes are unique because they are completely encompassed by constitutional issues in addition to factual ones. But it's the protections that we're afforded by our Constitution that resulted in tons of complex, logical, illogical, and eroding rights. Right to be free from search and seizure, arrest warrants, drug courier profiles. But anyway, let's start with the bare bones possession case. Possession of a controlled substance, a scheduled drug. These can be prescription medications, designer drugs, cocaine, substances that have medical value in addition to being abused, as well as those that do not, like cocaine. Now, for simple possession, the prosecution must prove that the substance is illegal, and that's done by testing the substance. All substances have to be tested scientifically before a state attorney would be able to proceed to trial. However, a defendant can plea without having that right, such as in the case of pleading to misdemeanor marijuana after only a Valtox test has been performed on the street. Valtox, for those of you that don't know, it's a liquid that police officers used to put on marijuana. If it turned blue, then that gave them probable cause to take the drugs and arrest you, search you, and beat you up. Now, in some cases, a prosecuting attorney may be forced to prove that the defendant was actually aware of the illegal nature of the substance. When I say of the substance, of course, I mean of the drug. This, of course, requires an appropriate motion, facts permitting. Highly effective if you want to throw a rock in the prosecutor's case and break their rhythm. Prosecutors must also prove that the suspect had control over the drug. Well, all of this makes sense. You found the drugs on him. Police officer found the drugs on the individual. Well, that's easy. And prosecutor would be very confident going into court, at least at the beginning. It gets harder when the controlled substance wasn't actually found on the defendant, wasn't being ingested, but rather it was in a common area. In that case, the prosecutor would first have to establish that the premises was controlled by the defendant. That doesn't mean that they had to own the property, but they must have exercised some dominion and control over the property or a car. A passenger in a car can be said to have dominion and control over it for terms of constructive possession. Now, I believe I read that the odds of conviction decreased by 75% according to Fort Lauderdale criminal defense attorneys, where substance is found and it's controlled and illegal and it was found in a common area and it's a constructive possession case. Well, these cases are easy winners. The drugs aren't found on the defendant. I think it's much higher than 75%. But where a prosecutor can prove all of these elements that I talked about, which are less than a vast majority of crime, it's just 3, sometimes 4 if certain issues arise, the conviction will be for a third-degree felony. A good rule of thumb is to consider all controlled substances as being felonies. with the exception of marijuana, under 20 grams, that's a misdemeanor. But cocaine, Adderall, ecstasy, Oxycontin, oxycodone, Xanax, if you get caught with this on you, you're looking at a felony. This raises issues as to eligibility for drug courts and special diversion programs. We'll touch base more on that later.